And we are live. We're at the Baldani Law Group studio here in Lexington, Kentucky. My name is Abe Mashni. I'm joined by my law partners, Russ Baldani, Tucker Richardson, Brandi Lewis. And first we want to say thank you for tuning in. We are kicking off this Suppression Series with a introductory episode. We're going to be talking about what is a suppression hearing, what's a suppression motion, what evidence can be suppressed. We're going to be talking about some stories that we've had and experienced through our careers, and just the mechanics of it. And so we want to, if you enjoy it, we ask that you share it. We have here, this is our Facebook counter, and it's a live counter. So if you enjoy our page, we ask that you like our page. And so with that, we're going to get into what are we talking about? What is this series? And Russ, do you want to kick us off?
Sure. So we're talking about suppression hearings, suppression motions. And obviously the place to start is, what is a suppression motion? And essentially it is a motion you bring before the judge that is seeking to have evidence thrown out. And Tucker's going to talk a little bit more about what specific types of evidence, but essentially it's an allegation that evidence that the prosecution is going to use against our client was obtained in violation of Kentucky Constitution, U.S. Constitution, or a statute generally. One thing to mention off the bat is sometimes clients will say, well, I want a suppression hearing because I didn't do it, or I want a suppression hearing because the case against me is horrible. So what it's not is a chance to go before the judge and have the judge test the evidence or test the case against our client. Rather, it's a motion to exclude evidence because it was obtained in violation. So that's what a suppression motion is and is not.
So whenever we're reviewing the evidence in any case, there's going to be two things that we're going to be looking at. We're going to be evaluating the evidence in that lens. It's going to be, how does this evidence affect the trial? What is the jury going to think about it? What is it, the guilt, the not guilt, how is that going to affect the trial? But then they also probably, and most importantly, initially is, were there any suppression hearings, were there any suppression issues that can be found in the evidence? Because that's a way that if you can, if there is an issue and you spot it and you bring the issue up, then that's a situation that the case can get dismissed and essentially avoid a trial. And so with that, Tucker, you want to talk about what evidence can be suppressed?
That'd be great. Happy to, Abe. The first thing I always get when I get a client is they're going, well, they didn't read me my rights. So can we get the case thrown out? And I'm going, well, there's only certain times they have to really read you your rights. Say in a DUI traffic stop, they pull you over, they're investigating whether in fact you've been drinking. They don't Mirandize you, give you your rights, and those statements are considered investigatory statements. It's only if they're going to really take you down in an in-custody situation and start grilling you at the police station or wherever in back of their police car that you're in custody, that they're asking you questions about did you do it or not, can we suppress those statements? So that the first thing I look at, can we suppress those statements that are made in an in-custody situation? Now, and one things that really kind of ticks me off is they say in a DUI stop they're investigating the DUI, but I think they should have to read you your Miranda warnings before they start asking you to do the ABCs and the number countdown test, because those aren't questions to elicit where were you, have you been drinking, and just kind of investigatory stuff. Those are actually evidence to be used against you, but the Supreme Court does not agree with me on that issue, And so they're able to get those in even though they don't Mirandize you. So the first thing I want to look at is the statements. The second thing, and I'm going to talk about a vehicle stop. If the police can't just pull you over at 2 o'clock in the morning just because they want to check you out. They can pull you over if they observe some violation of the law. So the things I see are no seatbelt. Number 2 is didn't put on a blinker to change lanes. Or cross the center line. Those are all things that they can use to pull you over, but they can't just decide, hey, I want to check this guy out, so I'm going to pull him over. So they have to have a legitimate reason to pull you over. So I look at that in seeing what if I've got a suppression issue on the stop itself. I always tell, my younger clients, if you're out past midnight, especially on a weekend, you're fishing a barrel. They're looking for you. So, my advice is, don't be drinking and driving. So, another thing that we look at in suppression motions is suppressing evidence that they found. In the vehicle sense, can they search your vehicle? If they do that illegally, a lot of times people say, well, sure, go ahead and search my car. Well, I always tell my clients, don't let them search your car. Let them make that leap, and that gives me a chance to find out later if they did it illegally or not. They also search in your house. They do a lot of times what they call a knock and talk. They will come to your residence. They've got evidence or neighbors' complaints that there's a lot of vehicle traffic in and out. So they come up and do what they call a knock and talk. And they knock on your door and say, hey, we're the Lexington Police Department or whatever police department. We've got some complaints about a lot of activity around here. Can we come in and talk to you? And once you invite them in the door, anything they see in plain view can form the basis of a search. So if you say, no, we'll talk out here on the front stoop, or say, hey, listen, I appreciate it, but I've got things to do. I'm going back inside, shut the door. But if you give them permission to come in and permission to search your house, then we don't have a suppression issue. So that's, if they come in regardless and say, well, we smell a plain smell of marijuana and search your house, we have a suppression issue possibly. Blood alcohol result test, those can be suppressed. If they didn't read you the implied consent, if they didn't observe you for 20 minutes, if the officer's not certified, every officer's certified out of the academy to operate the intoxilizer, but every 2 years they have to be recertified. So if they're not, then I can move to suppress that breath test. So I want to check all these things. But people just, like Russ said, that people come in and say, hey, listen, I want to suppress it because their case is weak. Well, I can suppress your statement, I can suppress your stop, I can suppress the search, but I just can't suppress the overall case just because it's weak.
Sure. And so what we're looking for is violations in law enforcement wherever they have violated a statute or a constitutional right, and that would give rise to the basis to suppress the evidence that they obtained. Is that correct?
That's exactly it. So, and like I tell my clients, don't make statements, don't give permission, let them do their job and don't, get in the way, but don't agree to anything and let them go ahead and do their job. And then later on, we might have a suppression motion that enables us to either get a better deal or get the case dismissed.
So these are the types of evidence that we're going to be talking about in this series. It's going to be suppressing confessions, suppressing drug searches, suppressing traffic stops. We're going to be talking about the case law, the facts, what situations to look for in your individual case, and basically just trying to inform people and let people know that there are ways, if your rights have been violated, that you can significantly help your case. And so with that, let's talk about the procedural, the mechanics of what a suppression is, the hearing, the motion, and with that, let's go to Brandi.
Thanks, Abe. So once you figure out what suppression issue you possibly have, you need to file a motion to suppress. Sometimes that needs to be supported by a memorandum of law, laying out your reasons of why you're trying to suppress the evidence. That's going to include the specific statute, regulation, or part of the state and or federal constitution that's been violated. Once that's done, then you will most likely get a suppression hearing. Then you have the opportunity to cross-examine the police officer after he testifies on behalf of the government and try to find out what actually happened. Then you get to make your arguments with the judge, and he or she may decide then and there. If they don't feel like making the decision at that point and need to review things further, you may be asked to brief that suppression issue, and then a decision is rendered. If it's favorable to you, then the evidence you're trying to suppress will be excluded. If it's not favorable to you, keep going.
Then you try to make your record and appeal it if that's what you have to do. So, and sometimes that is what you have to do. Sometimes I feel like the judges are wrong, and sometimes I'm right, and sometimes they're right. So that's just the way that goes.
So when can you file the motion? Is there time limits associated with it?
You can basically file it anytime prior to trial. In federal court, there's orders setting out time limits. If you are past that time limit and then receive evidence after that, which oftentimes happens, and then you discover a suppression issue, you have to file a motion for leave with the court to still file that motion to suppress, and that's usually granted because the judges, I believe, don't want to see somebody's constitutional rights potentially violated.
Okay, so I've got a story about this as far as when you can file a suppression motion. And so whenever I was in law school, I worked for the Commonwealth's office, and we had exactly
the dark side.
We had a trial in which I was given a limited license, and so I argued it and prepped it and did it. And so the morning of trial, it was a drug case where the guy was charged with possession of cocaine. The defense attorney on the other side filed a motion day of trial, morning of trial, and the judge suppressed half of the evidence that I intended to present that day, and which had a huge impact on the case. And so just because the trial is upcoming and on the horizon, that doesn't mean that evidence can't be suppressed and it could significantly help the case. And so with that, we've talked about a little bit about the benefits. Russ, do you want to talk about some strategical aspects of suppression hearings?
Sure. So with consultation with the client, we need to decide, should we file the motion? And it's not just completely black and white, clear cut. Here at our law group, we feel like it's important at the outset with our client to figure out what are the goals of our case. What are we trying to accomplish? And, it's not always an acquittal. Sometimes what we're trying to accomplish is avoiding jail or prison, getting probation, getting our client home incarceration. So you got to look at what's the goals of the case. And then decide, does filing a motion advance the goals of what we're trying to do? And I kind of look at suppression motions as sort of a spectrum, okay? On one far end, you might feel like if I file a motion to challenge this evidence, it's either frivolous or borderline frivolous, and if I walk into court, I'm going to have to wear a paper bag over my head. And an attorney is not obligated or even really ethically allowed to file a frivolous motion. So if your client is on video being read his rights, he acknowledges he read his rights, he signs a waiver of rights, he's been through the process 20 times before, he's an intelligent person, and then he confesses and he says, I want to suppress my statement, then that's the paper bag over the head motion, okay? On the other end of the spectrum is the motion that I call a codlock winner. You know, I would bet my house that I'm going to win this motion. I should win, and I fully 100% expect to win. So, as you might expect, neither scenario is very often happens. It's usually somewhere in the middle between frivolous and codlock winner. And so then you got to decide, should I file the motion? And very often I'll tell my client, you know, they'll say, well, what's the downside? And really the downside is it's work. And sometimes it pisses off the prosecutor or rubs the judge the wrong way because it makes the prosecutor work. They have to have a hearing. You know, the police officers are not happy that they're being drug into court and being accused of doing something wrong. And very often when you're trying to negotiate a case, the prosecutor will run it past the police officer and get their thoughts. And if they feel like they've been unfairly attacked, they might say no to a deal that you're trying to get. So you got to look at the pros and cons. But my belief is if you've got something well beyond the paper bag over your head motion and it's a legitimate motion, then you really should file it unless there's a good reason not to.
You know,
Okay?
In that vein, one of the things that if I've got a fairly good suppression motion, but I got a judge who doesn't like to suppress stuff, and that happens, some judges are very, very skeptical on suppression motions. I might use that threat of a suppression motion to drive a better deal and get the outcome that we're really seeking. So sometimes that's the way you want to play it. Hey, I'm going to file this, but rather than file that and put us all through a bunch of work, let's see if we can't resolve this.
Yeah, definitely. I mean, I had the exact situation on a young man. I felt like we had a decent motion. He was charged with trafficking based on a traffic stop, and they found some drugs, but he wasn't actually selling them to anybody. So I told the prosecutor, look, I think we've got a pretty legit suppression issue, but if you want to offer my guy possession, then we'll take it. The prosecutor declined. We had the hearing. The judge threw the case out, and he walked. So, but very often, and what you have to do is you can't just say to the prosecutor, hey, I got a suppression motion. You got to kind of put some meat on them bones. And you say, look, this is what I think. You know, I realize that we may not win it, but why don't we save ourselves some work and come to an agreement that your client is happy with? So I definitely agree with your point. It can be used as a bargaining chip.
So we've got result may possibly be case dismissed because the evidence gone. We have used as a bargaining chip because the prosecutor doesn't really want to work and maybe we can just reach a resolution to avoid the all or nothing deal of a suppression hearing. That the prosecutor may look at it as, well, I could get this conviction if we agree to it, or I could roll the dice and the judge may suppress my entire case.
Yeah.
But who wants to talk about the information that you can gain while having this suppression hearing?
Well, the thing I always look at is I get my
Hey.
officer on the stand, and basically when I do cross-examine him at the suppression motion, he's now made a second statement. He's written a report on the night of. At the preliminary hearing down in district court to hold it to the grand jury, he's under oath and tells that story. He then goes to the grand jury, he's under oath, tells the story. Then he comes to the suppression issue and tells the story. And it's hard to tell. There's always going to be little inconsistencies. And you're able to use those in a trial situation to point out that maybe his memory isn't as exact or her memory isn't exact as what they're portraying on the stand because they've told 2 or 3 different inconsistencies in that story. So, you know, that is one thing. And then at the end of the suppression hearing, it might not be suppressed, but you've been able to point out to the prosecutor that there's certain weaknesses in their case. And then we go back and then renegotiate what the plea offer could be. So I think that's, you know, And then if we lose the suppression issue, we can always do what's called a conditional guilty plea, where we reserve the right to appeal the judge's ruling, not suppressing the evidence up to a higher court. And sometimes you can use that once again to negotiate a plea, a better plea for your client. So
Yeah, I've had cases where I've lost them, and I thought I had a pretty decent issue on appeal. And with my client's agreement and consent, I go to the prosecutor and say, look, why don't we get this over with? We'll agree not to appeal if you'll agree to drop the trafficking to possession, or to do this or to do that. So the fact that you think you might lose a hearing doesn't mean you shouldn't file it.
Yeah.
Like I said before, we go into it along the lines of if it's a arguable, legitimate, non-frivolous motion, then we should file it unless there's a good reason not to do it.
Right.
correct.
So one of the things the suppression hearing does is you don't necessarily know what the testimony is going to be. The prosecutor, they have the opportunity to sit the officer down, go through the questions, and talk about what the evidence is going to be at that suppression hearing. But in a lot of cases, you just don't know how the officer is going to respond. I've had a couple of cases where I was frankly shocked that the officer said what he said on the stand. He gave me everything that I wanted, and I was just like, wait, what? You said what? And so, but there was a case a few years ago where there's sometimes where the judge just doesn't believe the officer, and as criminal defense attorneys, we love that situation. And so there was a case where my guy had a bad record. He was charged with it was a drug case. The officer thought that he saw a hand-to-hand transaction at a gas station, followed the car, did a traffic stop. One of the things that he messed up at is it was his first felony arrest, and so he got everybody out of the car, and he said in his police report that he was patting them down to search for narcotics. Well, you can't do that. And so the officers, they can pat people down for officer safety. And lo and behold, when he prepped for the suppression hearing, even though he put in the police report that he patted them down for drugs, he testified that he patted them down for officer safety. And so that was obviously a big point that we made to the judge in our arguments, is that, well, he changed his story. And so another thing that he said was during that pat down, he could immediately tell that my client had a very small, minuscule crack rock that was located in his hoodie. And so and he said that through my training and experience, I could immediately tell that he was he had the drugs on him. And so the judge, he kind of intervened, and he said, well, let's talk about your training experience. What training experience have you had? He goes, well, I went through the academy and so forth. He goes, well, how many drug cases have you investigated? He goes, well, this is my first one. And after that moment, the officer essentially lost all credibility. And what was a 12-year offer turned into a case dismissed. And so those are the types of results that you can get just by filing that motion, spotting that issue, and learning about that. And so anybody else want to talk about it?
I think we've kind of hit on the basics of what a suppression motion is, and a little bit about what you can suppress and the benefits. I think we kind of covered what we had here. So I'm happy with the way it turned out.
Okay.
I want to thank everybody for showing up today, and I hope you liked it. We'll be back again, and we'll get into some case law and some case studies, and expand on it a little bit more next time.
Thank you all.